Hello, everybody. Welcome to the Online Litigator, where our goal is to explore topics that help us do a better job of practicing law online. Recently, a lawyer from the Department of Justice wrote an opinion piece in Law 360 where he argued that remote hearings that we developed during the pandemic should become the default as we transition out of COVID operating practices. I interviewed the author of that piece, and I'll put a link to that conversation in the description of this video. But shortly after that piece came out, Law 360 published a rebuttal article taking the position that litigants should get to pick whether they appear remotely or in person. My guest today is the author of that rebuttal. Mark Eisen is an attorney in private practice. Mark, thank you for joining us.
Happy to be here. Thank you.
I want to start with a bit of a concession. It certainly seems to me that as we emerge from COVID, in-person court proceedings are returning as the default form of getting things done. Would you agree with that assessment?
From my experience, it's been jurisdiction by jurisdiction. Some have been much more open to returning quicker, and others, Northern California, for example, I've had a case out there that I feel like the judge may never have us in ever again. And so to me, it seems, unfortunately, a complete luck of the draw. You really, even in a jurisdiction, some judges want to see you and some don't, and it's become pretty unpredictable.
And you say unfortunate and unpredictable, I assume because that means that you don't know whether from any particular judge or any particular court, you can plan your schedule in terms of being there in person or you have to be online. You just don't know, right?
Right. And, a lot of hearings I've seen set, it looks like it's going to be in person. And then a few days out, a Zoom link pops up, and it becomes pretty difficult to plan accordingly. Each district that issues a sort of a general order on the issue that I've seen has just left it to the discretion of the judge. And then the judge has the discretion, depending on the type of hearing, whether they want to or not. Now, I've been a part of a few hearings where the parties have requested to be in person. So yeah, that level of unpredictability, I think, has been, not terribly difficult to deal with, but annoying.
Let me back out and ask you what I would call a foundational question. Do you think that this is even a real debate? I mean, do you think that there's any real chance that Zoom hearings are going to become the norm in the near future?
For certain judges, I imagine it will. And for certain types of hearings, I imagine it will. I think as we've seen as litigators, courts have become less and less likely to hold hearings on any motion at this point. Even dispositive motions are being ruled on the papers. I think that's unfortunate because I think litigators are losing out on the opportunity to become good oral advocates. But at the same time, I think it leaves judges who are already disinclined to have hearings generally. If they're going to have a hearing, they may be inclined to do it online. But I think the judges who are inclined to have hearings because that's just how they operate, are going to certainly be more inclined to bring folks back in person, because I think we have had the experiences of people not taking online proceedings as seriously. There being technical problems that judges, I think, become frustrated and litigants become frustrated dealing with. And so my guess is it will continue to be a judge by judge deal.
You mentioned a little bit about your practice. What type of remote proceedings did you participate in during the pandemic, during the thickest part of the remote litigation era?
We've had remote hearings on dispositive motions, status conferences, remote settlement conferences, remote mediations, remote depositions. So most everything in the pretrial context, we've had to deal with remote.
Are there any benefits to remote proceedings that you think that are worth saving and taking with us into whatever future we're headed towards?
I really think the benefits as it relates to how to say this right, I think giving attorneys the option is the safest way to proceed. That for any given reasons, whether it's family, whether it's, for a couple of years, I was based out of Chicago, and between the months of November and May, you may not know if you're going to get off the ground that day. So, things happen, flights get canceled. Life is, it is as unpredictable in person as it can be online with, the internet connections and power outages and whatnot. But there are a number of reasons why an attorney may choose the option, or a client may prefer that an attorney choose the option to appear remotely. It certainly makes dealing with having multiple hearings in the same day possible. And then there are a variety of reasons why an attorney may want to be in person. I mean, I tend to think about, when I was a very junior associate, and, now as a partner, do I necessarily want to go to each status hearing or, scheduling conference? Not necessarily. But as a junior associate, that's how I got comfortable enough, I think, to do dispositive hearings. And this is being able to work at home. This is how I dress now. And these are things that I can't do if I've got to be in court today. But at the same time, I like having the option, and I like, when I interview associates now, and I say, well, what is it you want to do? Why do you want to be a litigator? So, well, I want to take depositions, or I want to be in, I want to go to court. And I think something's missing when it's done remotely. Certainly some proceedings, some depositions can be done just as well remotely. But there's something missing. And I think, we get to a point where you get third, fourth, fifth year associates who've never had the opportunity to go to court because they haven't been part of a case where the judge allows it. I think that's particularly unfortunate.
And this idea of a hybrid model, this is a key to your opinion piece as well. You think that this hybrid model is the way that we should be going forward, which makes sense. But I guess I have a concern with the hybrid model. Under the hybrid model, parties get to choose whether they attend hearings in person or remote. But doesn't that type of a solution bring the results that you're looking for in terms of conversations in the hallway and adjourned proceedings for interaction? Doesn't that only work if both parties choose to attend in person?
Yeah, I think that's certainly true. And for significant hearings, I think what we would find, and what I've seen for the most part, is that if one side wants to appear in person, the other side will do it too. Particularly for substantive hearings, partly because, and I think, this sort of speaks to why in-person hearings remain important, is that if you knew the other side was going to be in court for the motion to dismiss, or the summary judgment, or the class certification motion, the supposition is being in person has an advantage. And if you're remote, maybe you're at a disadvantage. Maybe you can't get a feel for how the judge is going as well. And so given that folks tend to assume that being remote, if somebody is in person, is a disadvantage, I assume that if one side wants to appear in person, unless it is a very run-of-the-mill status, that the other side will show up as well. And so, and particularly if there is a desire to have an in-person meeting, if there's a desire to sort of open the door to settlement, or whatever issues might be on the table at the time, to have the side say, hey, I'm planning on being at the hearing. If you're there as well, let's grab coffee or something like that. That opens the door to those sort of interactions. And I think, it is unrealistic to say, let's go back in person no matter what. There are all sorts of I think, very valid reasons to allow attorneys to appear remotely. I mean, I know as a parent with young children, it can be very difficult when you're on the road a lot. I think particularly for female attorneys who have young children, or who may be pregnant, or just coming back from leave, that if you're being forced to fly all over the country because that's the nature of the job, you may be likely to leave that particular role and maybe go in-house. And so I think giving the opportunity to appear remotely will in all likelihood keep a number of working parents in the job that might otherwise feel like they're forced out. And so there are very valid reasons to allow folks to appear remotely. But I think as a default option, um, it could do a disservice more broadly to the profession.
Josh, the author of the original article that you responded to, he responds to your article by suggesting that perhaps remote proceedings may actually afford junior attorneys more opportunities to cut their teeth. And his logic behind that thought is that when travel is involved, fewer attorneys will actually travel to the proceeding. And therefore, a senior attorney will handle the smaller issues as well as the larger issues. But if the travel wasn't a problem and that the hearings were conducted remotely, the smaller issues might be more likely to be assigned to a junior attorney who wouldn't have to travel to gain that experience. How do you account for the potential of unanticipated benefits to new technology, things that we can't even foresee right now?
I think it's impossible to account for the benefits as technology evolves. I don't know that anybody thought we would be doing what we're doing now as far as video technology 3 years ago, and it became a necessity. And necessity bore a solution that, while it had its hiccups originally, has certainly proven to be very successful. But I would challenge that we would send senior attorneys to smaller issues or status conferences, because I don't know that that's necessarily true. I certainly have more than happy to have junior associates handle hearings appropriate for their year. And I just don't think there's a replacement for becoming comfortable in a courtroom and being comfortable in front of a judge. And I do think that there is a lack of seriousness when it comes to remote proceedings. The number of attorneys with funny backgrounds or experiences with court reporters interrupting hearings. They say, "Hey, I didn't catch that. Cut out. Can you repeat that?" It is lost an element that I think made in-person hearings fun. And truth be told, part of the reason I became a litigator was to go to court. I enjoy it. It makes me feel like more of a lawyer. Looking at the seal, behind the judge, having the judge up on the dais really, lends an element of seriousness to the proceeding that I enjoy. And I think if you don't get used to that, when the time does come for an in-person hearing, it may be very intimidating. But I welcome getting junior associates involved in hearings that are appropriate for their year. And I don't think the location of the hearing bears on that. And if at the end of the day, there was a concern, say from a client, say, I don't want a junior associate to cover a hearing, that would be true whether the hearing was remote or in person, if that's the issue. But otherwise, if it's a cost issue, it's going to be far cheaper to have a junior associate cover that hearing.
You point out some humorous moments in online litigation, and believe me, I have seen, maybe not them all, but I've seen a bunch of them. In fact, we have a video about a lot of those humorous moments in online litigation right here on the Online Litigator channel. But don't those things all happen in real court too? I mean, I've seen judges chastise lawyers for dress code violations in person. I think we've all seen jurors fall asleep in in-person trials. And our flow gets interrupted by court reporters on a regular basis in person too. They're stopping us all the time. Do you leave any room for the possibility that remote proceedings are perceived as less serious simply because they're recorded on video and we all have access to seeing what's going on, as opposed to in person, which is very temporal?
Um, I think the lack of seriousness, particularly in as a result of COVID. I mean, let me take a step back. Pre-COVID, remote hearings, I think were taken just as seriously. But as COVID required more and more remote hearings, I think we started to see issues of life. You couldn't really prepare for. Everybody's at home. My 1-year-old is asleep down the hall. And there's not much I can do if the hearing happens to be scheduled at noon. I've got nowhere else to go. And so when it comes time to go down for the nap and she's screaming, and it is what it is. Or as I mentioned, and this happens, every day almost. Some delivery and the dog running, at the door barking, and there are things that I think become difficult to plan for. And as a result, I say that we've gotten a little bit lazy. But I think I don't think it would surprise anybody to find out that the person on the other end of the Zoom was wearing gym shorts and sandals. But had a jacket on top and a tie, and that's just, it is what it is. And particularly when it comes to, and the fact that we've all been for 2 years, rather, we're forced more or less out of home offices. It eliminated an element of seriousness in proceedings that led to, it sounds like some pretty interesting experiences of attorneys doing hearings from bed, and just not willing to believe that they're in a courtroom, because at the end of the day, they're, probably in their living room.
Is there any possibility that some of your criticisms or your dislikes about remote litigation really touch more on working from home, and that if folks were perhaps appearing remotely from a litigation studio in their firm's offices, would perhaps that make you enjoy online litigation more, or is it still just the not being in person that is fatally flawing it?
Yeah, I do think you're right. At the end of the day, many or most of us have spent a year and a half or almost 2 years in our house. Offices by and large, we're not having folks back in. Some people sure said, to hell with it, I'm going to go into the office, I don't care. But I think for the majority, it was at home. And I certainly have become frustrated, feeling like I'm, as I mentioned in the article, I'm not working from home, I'm living at work, and I want to get out of here. And that's, I think, hit a fever pitch during the pandemic. When pre-pandemic, even though pre-pandemic I was working remotely, I was traveling, and I didn't really have that same itch. But it has created almost a claustrophobia, being confined to the house. So I think that certainly plays a big role. And it is hard to discount that, certainly. And being in an office, being in a conference room doing a hearing, or some sort of studio set up for remote proceedings in the office, that would certainly take away a bit of that element. But at the end of the day, I personally, and a lot, I think, obviously the article was a personal opinion. Personally, I like being in court, and I would like to get the younger associates I work with real court time. And I'd say one of the things that that is really, I think, a limit, it's sort of taken away from what I always, I was in moot court when I was in law school, and the prospect of, having an appellate argument, you get really, it was special, I mean, they're relatively rare. And, as it's hard to get out of my head that, a year's worth of Supreme Court litigants attorneys, many of whom probably making their first and only appearance in the Supreme Court they'll ever have, and they're doing it on the telephone. And I mean, I don't think anybody who dreamed of arguing in the Supreme Court dreamed of doing it on the telephone. And a lot of appellate arguments that were being done remotely, I think were particularly problematic. And I know the article focused mostly on trial litigation, but having judges talk over one another, or attorneys talking over the judge, because you can't see everybody and stop to see who's talking, and that while it certainly has led to Justice Thomas asking a lot more questions than he ever had before, I started to get the sense that judges were maybe asking fewer questions in some of the arguments that I had listened to at the appellate level, because it was just a little less serious, that it was a little more routine. And fortunately, I didn't have to do any remote appellate arguments, but it would have been a disappointment to not, walk up those steps, so to speak, or look at the judges. The last appellate argument we had was fortunately about 6 weeks before everything shut down, and it was an en banc proceeding, and it would have been really disappointing, I think, to do that in front of a computer screen.
For my last question, let me ask you to imagine that you have the ear of the Zoom research and development team. Is there anything that you think Zoom could do to make you like online litigation more?
I don't know. I mean, I think it is what it is. And if the parties are willing to take it seriously, if everybody is on board and are willing to view it seriously, then, I don't think there's anything to change. But if somebody isn't taking it seriously, which I will say, the court hearing situations were certainly not the norm. I pointed out some situations which were almost certainly an incredibly small minority of situations. I am certain that 99% of these hearings went off without a hitch. But in the context of mediations or depositions, I think it is just going to be very difficult to recreate that same level of seriousness and care that, I think we've all been in the context of a mediation that resolved at midnight, as the parties didn't want to leave without a deal. But that took investment from each side. Part of that investment was being there, and nobody wanted to get back on a plane empty-handed. And when it's done remotely and you just hang up, if you get, you got a TV on in the background or whatever, and you're in a breakout room, I think it's very difficult to recreate that environment. And I don't know that was the purpose of Zoom when it began, but it's been very creatively used. The breakout rooms are great, but it is what it is. It has an inherent limitation. If one side gets frustrated and they're going to draw a line in the sand, they hang up. Nobody has to get on a plane to go home. Nobody has to feel like they're leaving empty-handed. They hang up, they go downstairs and make a sandwich. And that I don't think there's anything Zoom can do about.
All right. Well, the article is Remote Hearings Are Ill-Suited Default for Litigation Realities. Mark Eisen, thank you for joining me.
Thank you.